For more perspective on the Senate impeachment proceedings, we now speak with Attorney Michael Yusingco, Senior Research Fellow at the Ateneo Policy Center. Good morning, Attorney, and thank you for joining us. Nice to see you.
Good morning. Good morning, Angela. Good morning to all your viewers and listeners.
All right, Attorney, after 2 weeks of impeachment proceedings, what's your overall assessment of how the Senate Impeachment Court has handled the case so far?
Well, from the perspective of our Constitution, it's very disappointing. What we've seen is very disappointing, and the reason for that is what the people involved have done is to pretend to pretend that this is a court of law, no? Yung mga tao, all of the people involved in the impeachment trial are pretending that this is a court of law, while at the same time also shamelessly acting in a political theater. So the combination of both has brought us into this mess, no? Specifically a perversion of the impeachment process, no? The senators and the lawyers are acting as if this is a court of law when it is not, but at the same time performing to the peanut gallery. So those two realities have perverted the impeachment process, and therefore, from the perspective of our Constitution, it's very disappointing to see that it has come to that.
Attorney, one of the private prosecutors, former Supreme Court spokesperson Theodore Te, had a Facebook post where he was saying that the impeachment trial should be more inquisitorial than adversarial. And to your point, that seems to be what's also happening now, that the impeachment court looks like it's leaning more towards a judicial atmosphere than a political one. Can we just get your thoughts on this?
Yes, Cheska, I think he's onto something. Attorney Te is onto something. And it's not just the fact that this has become like a judicial process, but the protagonists are also perverting this attempt at making it a judicial process, no? Because impeachment, really, if you look at the original design, which is patterned after the U.S. Constitution, it should be about addressing a particular issue, and that's the fitness of a high official to be in office, no? So the offense concerned should be that grave and that big that the fitness of the impeached official is there is an urgency involved to remove that person in office, no, that high official in office. So we've lost that element, and kahit ano na lang na charge nangyayari na ngayon, no? That's why we have 4 articles of impeachment, and what we have is like a mockery of a judicial proceeding. So I think Attorney Te's post is consistent with what impeachment should really be as designed in our Constitution.
Well, you're right, Attorney, because it seems the line between an impeachment trial and a criminal trial is getting blurred here, right? This process has become too technical, too judicialized, and too legalistic. So how would you differentiate the two, a criminal trial, an impeachment trial, and what should the public, the councils, and maybe even the senator judges remember here?
That's a great question, Pauline, and actually the difference is very simple. In a criminal trial, what we are trying to prove is a crime. There is a technical definition to it, right? And in addition to that, in the process of proving that crime, the quantum of evidence is very high, the highest, the strictest, and that's proof beyond reasonable doubt. Now, in the impeachment trial, it's totally different. An impeachment trial, there is no objective to define a crime. In other words, there is no effort, there should be no effort to come up with or to meet the technical definition or the technical requirements of that definition. In addition to that, the quantum of evidence in an impeachment trial is not proof beyond reasonable doubt. It is clear and convincing evidence, which means evidence that a regular person like you and me will believe as true. So it is not proof beyond reasonable doubt, but it's simply evidence that a regular person would believe to be true, such as the video that everyone watched of the Vice President making those utterances. So the difference between a criminal trial and an impeachment trial is actually stark. So it's really amazing and remarkable that those who are involved in the impeachment trial are able to blur the two types of trial as if they're mixed up.
Well, attorney, as we would always say, this is a political process, and whatever the outcome may be, this will definitely shape our political landscape. Now, having said that, the center judges are expected to be impartial. And based on your observations, the way they are conducting themselves, the way they are questioning the witnesses, the manner of the questions, do you believe that the center judges will actually decide based on the evidence presented, or they will actually prioritize their political career, political ambition, and that of the public perception?
That's a great question, Angela. And, we hope that it's a very difficult question to answer, but it's not. No, the answer is pretty obvious now that a lot of the senator judges will probably vote based on political calculations. And we've already seen that they will go through lengths to make sure that their political agenda is protected. No? Now, I say that because most of them are very eager to talk, right? Very eager to ask questions in the guise of making clarifications, but obviously we know that what those questions are for, right? So while we want the senator judges to appreciate the evidence presented before them and base their decision on that, I think most of them, particularly those who are always talking and hogging the limelight, it's pretty obvious that they will be voting not based on the evidence, but most probably according to what they want in 2028.
And on that note, we've spoken to several people, and I think Angela also interviewed former Senator Franklin Drilon on how this could be Presiding Officer Chis Escudero's redemption arc. We just wanted to get your thoughts on how he's been handling the proceedings so far as the presiding officer, and if this is indeed possibly his redemption arc.
I don't have any thoughts about this being a redemption arc, no, because whatever offenses he's being accused of is still there, right? The suspicion of his involvement in the flood control scam is still there. It won't disappear just because he's now the presiding officer. So that redemption arc theory to me is, well, not significant. But as for his performance as presiding officer, well, it's pretty clear that his legal background, his being a lawyer, is helpful. No? But it's also contributing to the to the pathology that I just mentioned before, that the impeachment trial is being formed or reformed into a criminal trial. His background as a lawyer is good if this were a criminal trial or if this were a judicial trial. But probably because of his legal background, his lawyer background, it's making the judicialization of the impeachment trial much more palpable. So I know maybe that's not a good thing, right? Because what we want, what we want is an impeachment trial that is not trying to pretend or trying to be a judicial trial.
Well, Attorney, in terms of Article number 4, which is about the grave threats, it seems the prosecution is ready to wrap up its presentation. Their last witness is Attorney Melvin Matibag on Tuesday. But what do you think? Do you think the prosecution has been able to establish the evidence already? And do you still think this is the strongest article among the 4?
Well, in the beginning, I never really considered, this ground as impeachable. But after hearing Attorney Lotok, I think the tide has turned in my mind. No, I think the prosecution was able to prove that the utterances were made. I think that's already established that Vice President Duterte made those utterances. No? So that's not a problem anymore for the prosecution. I think what they still need to do, or at least strengthen, is to show that those utterances amount to a betrayal of public trust and a culpable violation of the Constitution. Attorney Lotok touched on that briefly, and I think it's what convinced me that this is a strong ground now. So for the next witness for the prosecution, I think they have to buttress that, that those utterances are indeed can be considered as a betrayal of public trust and a culpable violation of the Constitution. That's the only part that I think that is lacking, or at least needs strengthening.
How exactly, Attorney? I mean, for the prosecution, they already established the authenticity, the source, the provenance. So how can they still establish that this was a betrayal of public trust?
Well, that's a great question. And my unsolicited advice is they have to provide an expert view, an expert opinion to help the senator judges understand that those utterances can be considered as a betrayal of public trust, because the term betrayal of public trust and culpable violation of the Constitution, these are legal terms. These are constitutional terms that have constitutional meaning. So for the senator judges to put the two together, the utterances and those legal definitions, those legal meanings, they will probably need help from a constitutional expert or an impeachment expert, so that they will be able to justify whether a conviction or an acquittal is forthcoming. So right now, that link is still weak. The link between the utterances and those constitutional definitions of betrayal of public trust and culpable violation of the Constitution. For me, as a litigator, it's still weak, and for the prosecution, they have to sort of solidify that in the minds of the senator judges.
Now, on the issue of BIR box, I remember during the impeachment case of the late Justice Corona, it was former President Noynoy Aquino who wrote the gave a written request, no, to the BIR to unseal or open or give the or issue, no, bank statements of Justice Corona. But this time around here in this case, in the impeachment case of Vice President Sara Duterte, should the President also, which is President Bongbong Marcos, issue or write a written request para matapos na ma-unseal, no, itong BIR box na ito, mapag-usapan yung financial records ni VP Sara, or this will look bad, no, doon sa side ni President Bongbong Marcos, saying na baka nakikialam siya dito sa usapin ng impeachment.
Well, it all depends on what the impeachment court does, right? If the impeachment court denies the motion, then there's no reason for President Marcos to, make that decision to open or to give access to the BIR records. On the other hand, if the impeachment court grants the motion, President Marcos has no choice but to give his permission to open the BIR records. So, unilaterally, President Marcos can't act because there's no reason for him to act, right? So, if he does give his permission without any prompting from the impeachment court, then obviously that is susceptible to criticism as a political vendetta or a political move against the vice president, which, he shouldn't do, right? So whatever the impeachment court decides on regarding the motion, President Marcos really has no choice. If it is granted, then he has to give the permission to open or give access to the BIR records of Vice President Duterte.
Attorney, we only have two impeachment cases that made it to the Senate. Both resulted in removal. Well, former President Estrada was deposed via people power, and Chief Justice Corona was convicted. Just in terms of our history with impeachment trials, what are the lessons and takeaways that we need and the precedents that we need to understand that were set by these two trials that we need to bring into, or how does it compare to this current impeachment trial?
That's a great question, Cheska, and very difficult to answer. All I can say now is that given everything that we know with the three impeachment trials, I think we really have to revisit. We have to revisit what the impeachment mechanism actually means or truly means in the context of our Constitution. So, in the impeachment trial of President Estrada, I was there personally and I saw it. There was already an attempt to make it like a judicial process. So there was already an attempt to mirror the judicial procedure, of a trial. Now, there was also an attempt at that time to be loyal to the original design, which is the copying from the mechanism that's provided in the U.S. Constitution. So it was, kumbaga parang noon, they were trying hard to sort of blend the two thinking together, making it like a judicial process to localize the context, but also being loyal to the original design. Now, in the Corona trial, it was more of the same, right? It was more of the same. There was no changes made or adjustments made, except that in the Corona trial, I think the senator judges were given more leeway to act less as judges, but more as advocates, giving them more opportunities to ask questions, giving them more time to confront witnesses and counsels, which, by the way, is not provided in the U.S. model. The U.S. model specifically prohibits senator judges from talking, from dialoguing with counsels and the impeached official. So this is where we have a local flavor, no? And now in the third impeachment trial, we see that, this has gone bananas already. This particular aspect of our impeachment trial. Senator judges now are basically like litigants already and counsels for the litigants already. No? And that has made our impeachment model perverse in that sense, because now even senator judges can act as advocates for the parties involved. So if we are learning lessons here, I think that will be number one in the list. Senator judges becoming advocates in the impeachment trial, which is contrary to the original design, which is found in the U.S. Constitution.
Well, outside this impeachment trial, attorney, there are also several political developments and investigations, including that of the NBI, which Attorney Melvin Matibag just announced recently, and that is they're opening an investigation into the anomalies of the 2019 Southeast Asian Games. Now, yesterday, Senator Alan Peter Cayetano made a manifestation, a representation, calling it unfair, saying that if the NBI wanted to investigate it, they should have just done it quietly without announcing it ahead of Attorney Matibag's testimony on Tuesday. So what do you make of the timing? Some are calling it ill-timed and suspicious. So what are your thoughts?
Well, yeah, you can say that the timing is suspicious, right? But it's the job of the NBI to investigate, corruption allegations. Obviously, we can hold the NBI to account for making the announcement public. Again, connecting it to the impeachment trial. But I still find it, ridiculous for an impeachment court composed of 19 senators to be intimidated by a mere announcement. By a mere announcement of an investigation. I don't see the sense there, right? That an impeachment court comprised of many individuals, senators at that, would even be intimidated by this kind of investigation. Right? As a matter of fact, some of the senators are currently being investigated, right? Even the presiding officer is currently being investigated by the ombudsman. So all that drama about intimidation and timing, well, it's just that, all drama, to bring attention, to them, I suppose, to hug the limelight for many minutes in the impeachment trial, but I don't see the intimidation factor here.
All right, and with that, thank you so much for sharing your time and your insights with us. That was Attorney Michael Yusingco, Senior Research Fellow at the Ateneo Policy Center. Thank you, Attorney.